All attendees are in listen-only mode.
Hi, welcome everybody. We are going to give just another 1 or 2 minutes here for some late arrivals, then we're going to go ahead and get started. Okay, we're going to go ahead and get started here, and if some late arrivals come, we'll catch them back up to date. So I encourage everyone to ask questions if they have any. There's a place where you can ask questions on GoToWebinar. There's also a chat box. If I come across something that is confusing, right, this is expungement law, it gets a little complicated from time to time, please feel free to throw in a question. I'll stop and ask it or answer it. So thank you everyone for joining. My name is Matthew Stubenberg. I am the IT director and I am an expungement staff attorney here at the Maryland Volunteer Lawyer Service. And the Maryland Volunteer Lawyer Service is a legal services organization here in Maryland that provides free legal help to low-income Marylanders. And the MVLS specifically works with other attorneys who are looking to give back pro bono hours. And so you get a wide swath of attorneys from all over the state who are looking to kind of give back to their community. And MVLS acts as a facilitator and kind of a mentor in different legal areas, and my specific area here is expungement. So why has MVLS taken such a kind of a big stance on expungement? So I think we're all probably familiar with why expungement is so crucial, right? It helps with employment, housing, education. It can hurt your credit, and then even in social circles, you know, it can be difficult to try new things or to sign up for new positions if you're worried that your criminal record might get out. So before we get on too far, let's go over what expungement actually is. Expungement is the removal of a Maryland criminal case from a person's record. So what I'm going to be talking about today only applies to Maryland cases, and it only applies to criminal cases, some citations and some traffic cases. So what does that mean? If you have a case in Virginia, Virginia has a completely different set of laws. It might be eligible for expungement under Virginia law, it might not be. If you have a Maryland family law case or a Maryland foreclosure case, something like that, odds are you can't get it expunged. This is only for criminal cases. So that's the first kind of major thing that we should figure out. And you know, if you think, oh man, I'm sure I'm the only person out there with a criminal record, I assure you, you're not. In 2015, 60% of all Baltimore City District Court cases were eligible for expungement. So the vast majority. Very few of those actually get expunged, because in order to get it expunged, you have to take the affirmative step to file for expungement. It's not automatic. And so out of the almost 23,000 cases, only about 8,000 petitions were filed. And as of 2014, which is when the last numbers were pulled, there were 1 million eligible cases in Baltimore City alone. So there are lots and lots of people who have criminal cases eligible for expungement, and the vast majority of criminal cases are eligible for expungement. And if you're ever curious what that looks like, this is just a cross-section of Baltimore City. Each pin represents a person with an eligible case for expungement, and this is only from the year 2014, I believe. If you load up all the years, it breaks the program. That's how many cases there are. So if you are thinking, I have a criminal record and I'm sure I'm the only one, I assure you you're not, but you're on the right steps to try to get it expunged. And I'm also glad that everybody here is on the webinar, because expungement affects almost every Marylander to some degree, even if it's through family members or friends. This information hopefully will be very useful to colleagues, to friends, to family members, to other people who have criminal records who might not be aware that their criminal record even exists or is eligible for expungement. And it should be noted that in Maryland, if every criminal case that had any kind of touch with the court, even if the case was found not guilty, even if it was dismissed or a null pros was entered, even if you beat all your charges in court, that case is still on your record until you go and you affirmatively file for expungement. There is no automatic expungement. So a lot of people think, oh, well, I was found not guilty in that, or the state declined to prosecute in that. It's still on your record. It might say not guilty, or it might say null pros. But unfortunately, as I'm sure we're all too aware, many people don't give the benefit of the doubt or even continue reading, right? And so if you were charged with some heinous crime like burglary, the first degree, or maybe even manslaughter or murder, but you beat the charges, you might still be kind of effectively discriminated against because of those charges, even though you were found not guilty. So it's really important to get rid of those cases. So I'm going to go over what the law is, because the law does not allow everything to be expunged. It's only a select handful of charges and dispositions in certain situations that can be expunged. We're going to go over kind of a practice case just to see how it plays out in the real world. There's some forms and some kind of administrative how to file it if you want to file it on your own. And then I'm going to go over how to ask MVLS for help or other organizations for assistance. Most of them have income qualifications, so keep that in mind. The one thing I cannot do, unfortunately, is give specific legal advice. You have to become a client of MVLS in order for me to look at your case and say, yes, your case 1, 2, 3, 4, 5 is eligible for expungement. I can talk in generalities or vagueness. I could say kind of hypothetical situations. This is what would be eligible. Unfortunately, I can't look at your specific case today. If you'd like me to, you have to apply to MVLS. So the law is covered under these two statutes, 10-105 and 10-110, and they're broken into pretty much two categories. It's non-convictions that are eligible for expungement, and then certain convictions that are eligible for expungement. So it really matters what you received on this, and that can be called the verdict or the disposition. The disposition is generally what we use. And so it really depends on what you received in the case. I hear all the time, oh, I was charged with murder, can I get that expunged? Well, it depends. It depends. Were you found not guilty or were you found guilty? It really depends on the disposition, almost more so than what you were actually charged with. So we're going to go over non-convictions first. So this is where your case does not include any convictions on any charge. It can be anything other than a conviction, but no conviction. So if you were charged with 10 things, each charge has something other than a conviction as a disposition. So what are some of these other dispositions? They include a nolle prosequi, which is Latin, and it basically means the state declines to prosecute in that case. It's also known as a null pros. A not guilty or an acquittal, a judge or a jury found that there was not facts beyond a reasonable doubt. A dismissal, the court threw it out for whatever reason. A transfer to juvenile court. In Maryland, if you're charged with certain crimes, like assault in the first degree or manslaughter, and you're a juvenile, you're under 18, you automatically get charged as an adult in adult court, and then you have to ask the court to be waived down to juvenile court. If that happens, you still have a record in adult court. It'll say charged with whatever, your disposition is juvenile transfer or transfer to juvenile court. So even if you were ever in adult court, there's still a record of that. There's a stet, which is kind of like a purgatory for criminal cases. It gets placed on something called the stet docket, and that's where it sits, usually never to be touched again. And then finally, probation before judgment, which is not a conviction. It's usually used as kind of a first time get out of jail free card. So if this is your first time in on, say, something like a drug offense, odds are you'll get a probation before judgment. So not all of these are necessarily automatically eligible for expungement, but most of them are. I'm going to go over a few of the caveats and details here. And again, if you have any questions, you have any comments, please feel free to put them into the questions or into the chat box, and I will answer them the best I can. Okay, the best dispositions here. So these are the dispositions that everyone identifies as basically you won. So they consist of a nolle prosequi, a nolle pros, not guilty, an acquittal, a dismissal, and a transfer to juvenile court. And for all of these examples, we'll pretend you were only charged with one charge. You only have one charge in your case, and you received this disposition on it. So you went to court, you were charged with, let's say, manslaughter, and you received any one of these dispositions, it is eligible, that case is eligible for expungement, and it's eligible immediately. Now, the one caveat is if you're filing within 3 years, so you go to court today, your case is, you're found not guilty, you can file for expungement, but the state makes you give up your right to sue the state for anything related to that case. And the reason they make you do that is when they expunge your record, most courts will actually shred the entire file, everything to do with it. And so if you then turn around and sue them and say, hey, when the police officer arrested me, he put the handcuffs on, he broke my wrist, and now I want medical damages, they have no records of what happened, so they can't defend themselves. So I kind of see why they do it. I think there's a better way, but that's besides the point. So if you don't plan to sue anybody in this, you can get it expunged right away. If you do plan to sue somebody, the state, the police, somebody who filed a complaint against you, whoever it may be, you have to do that first before getting that case expunged. So all of these dispositions are pretty good. It doesn't even matter what you were charged with. If it resulted in a nolle pros, not guilty, dismissal, or juvenile transfer, you can get it expunged. And interestingly, the juvenile transfer, it means you were sent to juvenile court. The adult record is eligible for expungement regardless of what happened in juvenile court. Juvenile cases are all sealed by default, so most people shouldn't be able to see those anyways. But now you can get the adult one expunged regardless of what happened. So here we have a case, and this is on Maryland Judiciary Case Search. If you've never used Maryland Judiciary Case Search, it's the state's website where they have everyone's criminal and civil cases that they've ever been a part of. And it goes back to about 1990, 1985. And how it works is you just type in your name, and I'll show an example later, and you can look up your criminal record in Maryland. Now, it is a little touchy. Sometimes they have typos, especially if you have a common name. It can be difficult to find your specific cases. If your name's spelled Sharon with 2 R's, and you can't find a case, try searching by 1 R. But it's a very useful website. So here we have somebody who was charged with fraud. They received a nolle prosequi from 1999. This case is eligible for expungement. We don't need to know anything else about the case, right? We don't even need to know what they were charged with. They received a nolle pros. We'll say this is the only charge in the case. And it's from 1999, so it's more than 3 years old. Now they could get it filed, they could still expunge it even if this was 2018, but they would have to sign that waiver saying they're not going to sue anybody. But because this is way outside the 3-year window, it's from 1999, they can file this without any hiccups at all. So this case would be eligible for expungement. That's where the disposition is. You want to make sure to look at the disposition and not the plea. You can plead anything. You can plead guilty but be found not guilty. Well, that'd be pretty rare. Usually you plead guilty and sometimes you get a probation before judgment. But you can plead not guilty and be found guilty. What you need to focus on is the disposition. Okay, so now we have the next set of dispositions. And the next one is called a stet. And the stet is almost like the last group where it's eligible for expungement, except it's not eligible for expungement right away. So if your case was null prost or nolle prosequed, you can get that expunged right away. If it was stetted, you have to wait 3 years from the disposition date in order to get that case expunged. So here we have a case, and again, we don't actually have to look at what they were charged with. It doesn't matter. This could be murder. It could be jaywalking. What matters here is that they received a stet. And the only requirement with a stet is that they have to wait 3 years. So we take a look at the disposition stet. We take a look at the date. It's from 1997. More than 3 years have passed. This case is eligible for expungement. Finally, we get to probation before judgment. So this one is slightly more complicated. It has 2 serious caveats. So first, it's called a PBJ. That's usually the nickname. A lot of people tend to call it a PB and J, right? Peanut butter and jelly. I try to refrain from it. People won't take you seriously if you call it a PB and J. So make sure you call it a PBJ or the full name, probation before judgment. Probation before judgments are eligible 3 years after the disposition date usually, with 2 big exceptions. The first one is, and this is where you actually have to look at what they were charged with. The first one is a DUI or a DWI. If you get a probation before judgment on a DUI or DWI, it is not eligible for expungement. It's just a weird carve out in the law. I think Mothers Against Drunk Driving had some influence, and they were able to get that added. And so unfortunately, DUI, DWI is not eligible for expungement. So you get a probation before judgment on murder and get it expunged, although that would be kind of unlikely to get a PBJ on murder. But if you get a PBJ on DUI or DWI, you cannot get it expunged. It's not that you have to wait longer. It's not that you have to jump through more hoops. It's just not eligible ever. The second big exception here is something called the subsequent conviction rule. So what it says is if the person has a conviction within 3 years of the probation before judgment, then the probation before judgment case is not eligible for expungement. It's the state's way of saying, look, we gave you a PBJ. It's not a conviction, so we're taking a chance on you. If you screw up in the next 3 years and you get a conviction, we're not going to let you get that original PBJ expunged. So you have to take a look at the rest of your record. If you've been convicted of something within the next 3 years, odds are you cannot get that PBJ expunged. But it's only 3 years. If the conviction is 10 years later, that's okay. So here we have somebody who was charged with driving under the influence of alcohol, DUI. They received a probation before judgment in 2010. This case is not eligible for expungement. It's not that they have to wait more years. It's not that they have to pay a bigger fine. It's just not eligible. And here's an example of the subsequent conviction rule. So here we have somebody who was charged with assault in the second degree. They received a probation before judgment. Notice they pled guilty, but received a probation before judgment. That's what we're concerned about, the disposition. And they received it in 2009. And unfortunately, the very next year, they picked up a conviction on attempted manufacturing of CDS, controlled dangerous substance, drugs. And they were found guilty. And this is 2010, so it's 1 year later. So because of this subsequent conviction, they cannot get this original assault second degree case expunged. If this case did not exist, case number 2 here did not exist, or it existed but they were found not guilty or null prost or something, then they could get case number 1 expunged. You have to take a look at the next 3 years if you see a probation before judgment. Okay, so those are non-convictions. Most non-convictions are eligible for expungement. That's kind of the rule of thumb. If you weren't found guilty on anything in a case, usually you can get it expunged. There's a couple caveats there with the DUIs and stuff like that, but usually you can get it expunged. Convictions are much harder. The state legislature has not been as generous when it comes to expunging convictions, and they fall into two categories. One is a kind of a short waiting period. You wait either 3 or 4 years, and the next category is a long waiting period. It has either 10 to 15 years. So we're going to go over the short waiting period first. These are nuisance crimes. So the state has said, if you're convicted of one of these small, really minor nuisance crimes, and the group that advocated for this was a group that represented homeless individuals. And so it kind of goes hand in hand with, unfortunately, with being homeless, that they tend to pick up a lot of these charges. So if you are convicted on one of these charges that you see on the screen right now, you can get it expunged. The only caveat is you have to wait 3 years. And technically, it's 3 years after the sentence, any sentence or probation. But usually for most of these, you don't get probation or a sentence. It's just a fine. So all of these are eligible even if you were convicted, but you have to wait 3 years from the disposition date, not the incident date, the disposition date. So here we have somebody who was charged with urinating in public. They were found guilty. They had to pay a $100 fine. This was from 2017. So while this will become eligible, it's not eligible today. It would have to be 3 years from 2017. The next big one here is marijuana possession. So marijuana possession, even if it's a conviction, is eligible for expungement. And the general rule here is all marijuana possession, and it's only possession, not distribution, not kind of attempted manufacturing or distribution, any of that kind of selling marijuana, that's still not eligible for expungement. But if it's just possession, all you have to do is wait 4 years from the disposition date, and you can get it expunged, regardless of the amount. There is a kind of a small little piece I'll go over here is if it's less than 10 grams, you can get it expunged immediately. But usually you have to then prove the weight of the marijuana, which gets a little tricky. Otherwise, all marijuana weight for marijuana possession, 4 years, and you can file for expungement, even if it's a conviction. So here we have somebody charged with CDS possession of marijuana. Disposition date, they were found guilty, and the disposition date was 2010. So this is eligible for expungement. It's been more than 4 years. It doesn't matter how much marijuana. This is eligible for expungement. So now we have the long waiting period category of convictions. And these are they fall into a slightly higher degree than nuisance crimes. They include assault second, trespass, CDS possession, paraphernalia, prostitution, gambling, a couple of gambling offenses, theft, tax claims, and there's a whole number of other ones, but these are really the most popular ones. And you can see the full list here at nvlslaw.org/new expungable convictions. Now, the first thing I want to say is this only covers the misdemeanor version of these crimes. So some of these crimes can only be misdemeanors. But there are others that have a misdemeanor and a felony component. So for theft, for example, depending on how much you're charged with stealing, it can be either a misdemeanor theft charge or a felony theft charge. Whether or not you can get it expunged depends on whether or not it's a misdemeanor. If it's a felony, all right, it's over, I forget what the exact number is now, but if it's over, I think it's $1,500, then it's considered a felony, and then it falls outside of this and you cannot get it expunged if it's a conviction. Now, we're not quite done yet. So first you have to make sure that what you're charged with is a misdemeanor. Next is the really long waiting periods, unfortunately. So for most of the crimes that you just saw, if you were convicted, you can file for expungement after 10 years. And that's from the end of any sentence or probation. So if you get convicted on a misdemeanor theft charge and you get a year in jail, it's 10 years after that year in jail is up. Now this is 10 years for everything except assault second, common law battery, and crimes designated as domestically related, but those are usually assault second cases anyways. For those cases, you have to wait 15 years from the end of any sentence or probation. And so if you were convicted of assault second, you had 2 years of probation, you finished your probation fine, nothing wrong with that, you would have to wait 15 years from the end of your probation before filing for expungement. Now, if that's not bad enough, there's one more caveat here. Here's an example here of the waiting times. So here we have assault second. It's 15 years from the end of the probation date, which is right here. So that's from 2010. So this will become eligible in 2015. Oh, sorry, 2025, right. So if that wasn't bad enough, there's one more rule here that applies. And it's similar to the probation before judgment. It's the subsequent conviction rule again. You cannot have a subsequent conviction within the time frame that you're waiting. So let's say it's assault second. You got a year of probation, then you have to wait 15 years after that. If you're convicted of another crime within those now 16 years, you cannot get that case expunged. So here we have an example. Somebody was charged with assault second in 2009. Then in 2014, they were convicted of robbery with a deadly weapon. This assault second case is now no longer eligible for expungement. Now, it can be kind of tricky to find the end of the probation date on case search, so you have to sometimes look around for it. So here it is for a theft less than $1,000. So for this case here, the end of the probation date is 2011, and so it'd be 10 years from the end of the probation date, which is 2021. Now, what happens if you get another case that's eligible for expungement later on? What happens is you then have to wait until that case becomes eligible. So for instance, we have a theft case that falls under the exception, even though it's a conviction, right? It's on that list. So you have to wait 10 years from the end of probation, so it's 2021. But then unfortunately, here in 2016, let's say you pick up a conviction for assault second. While assault second is eligible for expungement, you have to wait 15 years from the end of any sentence or probation on that case. So you would have to wait until this assault second case becomes eligible for expungement before filing for the theft charge. See, and so unfortunately the time kind of tolls. So you have to start over. And so here we have this assault second, which will become eligible in 2033. And so now what became a case from 2010 that would have been eligible in 2021 is now eligible in 2033. So when you're dealing with convictions, whether or not you have a subsequent conviction can be very important and add a very large amount of time. The last piece here is victim notification. So the state, if it's one of these long waiting period convictions, like a conviction on theft or assault second or CDS possession, for those, they will try to notify the victim if there is one in the case. So if this is an assault case, maybe involving a prior girlfriend or boyfriend or something like that, just keep in mind that in theory they could be notified and they'll be given a chance to object. For the long waiting period convictions, the judge also has the ability to deny the expungement based on a risk to public safety or the interest of justice. If it's just the case was null prost or not guilty, those go through automatically. The judge doesn't have any discretion to say no. If it's a long wait conviction, if you're waiting either 10 or 15 years, then in theory the judge can deny it based on risk to public safety or interest of justice, depending on what the rest of your record looks like, what you've done with your life since then, et cetera, et cetera. Okay, so now in all our examples, we've kind of assumed that each charge or each case only had one charge. What happens if you have multiple charges in a case that all have different dispositions? How are those dealt with? Well, unfortunately, not well. Under something called the unit rule, which applies to all of the expungements, convictions, non-convictions, short wait, long wait, if you have a charge in a case that cannot be expunged or cannot be expunged yet, it has a waiting period, then none of the other charges can be expunged. In order to expunge a case, you have to be able to expunge every charge in that case. And so if you find yourself looking at a case and saying, well, I'm going to expunge this charge from that case and this third charge, but not the second one because I can't do that, then you're doing something wrong. You can only expunge an entire case as a whole at once. And so if you're, and I'll show you an example of what this looks like. Now, technically, the statute says it's all charges arising out of a single incident. Usually this means that it's all in one case. But every once in a while, sometimes the court will split it into different case numbers, so it'll look like they're different cases. If it all came out of the same, traffic stop, it all came out of the same bar brawl or the same burglary, it's all going to be related, regardless if they put it in different cases. Usually, though, they try to stick it all in one case. So here we have somebody who was charged with burglary in the first degree. They received a dismissal. They were charged with theft, received a dismissal, and theft, $500 plus, which at the time would have been a felony. They received a conviction on that one. Unfortunately, while theft misdemeanor charges are eligible after 10 years, theft felony charges are not eligible. So unfortunately, this case as a whole cannot be expunged. You cannot go in there and expunge these two charges but leave this one. If one charge cannot be expunged, the case as a whole cannot be expunged. Here we have somebody who received a charge, a different case. It looks like intoxicated public disturbance, received a not guilty in 2017. They got a disorderly conduct and they received a stet. Now, stet dispositions are eligible for expungement, much like not guilties are, but the difference is a stet you have to wait 3 years before filing. So this is from 2017, which means this case will be eligible for expungement in 2020. So you cannot go in and say, well, this one is eligible today, and then I'll come back and expunge this charge in 2020. It's all or nothing. Okay, the next big thing here is something called the pending criminal proceeding rule. What it says is if you have a pending criminal case, you cannot file for expungement in anything. So let's say you have 100 cases, going back 10 years. You were found not guilty on all of them. You took them all to trial and you beat the charge every time. But then you got pulled over by the police. They've charged you with something and it's pending. You know you're going to beat it. You have the photo evidence to prove that it wasn't you driving the car or you breaking into the house or whatever it is, and you're going to win hands down. It doesn't matter. If you have a trial date coming up, you cannot file for expungement on any charges. You have to deal with that case first and have it disposed of, however it may be disposed of, before filing for expungement. Now, if you're on probation or parole, you've already been found guilty of something and now you're serving a probation or parole, that does not count as a pending criminal proceeding. It's only if there's no disposition or verdict yet. Traffic, it gets a little bit confusing, so I'm going to go a little bit fast through it. Major traffic offenses follow the same expungement rules we just talked about. And major traffic is considered anything you could have received or could have been incarcerated for. Not necessarily that you were or that you were likely to, but that you could have been. So something like driving without a license is an incarcerable offense. Driving on a suspended license is an incarcerable offense. That follows the same law that we just talked about. So if you're found not guilty, you can get it expunged. If you're found guilty, odds are you cannot. Now, if it's a minor traffic offense, that falls under the jurisdiction of the MVA, and the law that we just talked about doesn't apply. Now, the good thing is that these traffic cases, the minor ones, will come off of your record automatically. And so you don't need to file for expungement. They should just come off your record automatically if you go a certain amount of time without a traffic incident. Usually, it's tough to get into minor traffic court expungement law here. We don't have a whole lot of time. But it usually deals with you have to go a certain number of years without being arrested for any kind of moving violation. Once that happens, the MVA will remove those cases from case search and expunge them. If you're interested in knowing what cases are considered incarcerable, you can go online and actually type in Maryland incarcerable traffic offenses, and it will bring up the full list. The biggest one we see by far is driving on a suspended license or without a license. Okay, so let's take a quick look here at someone's record. Right, there's no names or anything. So here we have person one. They were charged with assault second, received a null pros, and theft less than $1,000. If it says less, it's usually safe to assume that it's a misdemeanor charge, and they were convicted of this. The only other case on their record was theft from $10,000 to under $100,000. Unfortunately, that's going to be a felony, but they were null prossed, and they had a motor vehicle unlawful taking, which was also null prossed. So which one of these cases, if not both or zero, are eligible for expungement? So we just go case by case. So we see this null pros. We go, okay, this charge is fine because all null processes are eligible. So now we have to take a look at the other charge in the case to make sure there's nothing holding it up. So we see this guilty. We say, okay, we're in trouble here. It's theft less than $1,000. That's one of the eligible convictions. And the disposition date here is 2014. So if we remember back, you have to wait 10 years from the end of any jail sentence or probation. And it looks like they received a year and 1 day in jail. And so presumably this would be from November 19th, 2015 plus 10 years. So this case will become eligible in 2025. Here we have case number two. This was null pros. We can ignore this. This was null pros, so we can ignore this charge as well. So case number two is eligible for expungement today. Now it's 2017, and so it is, while it's eligible, this person would have to give up their right to sue anybody and everybody related to that particular case if they wanted to expunge it today. So here we have person number two. They have a possession of marijuana case from 2009 that they were found guilty on, and a conviction on open container alcohol. So case number one is eligible for expungement. And the reason is this possession of marijuana is all you have to do is wait 4 years. It's 2009, so this is when the disposition date is, so it's been more than 4 years. Open container is a nuisance crime, so you have to only wait 3 years. And so this case is eligible for expungement, even though they're both convictions. They fall into that short time wait period conviction category. Here we have case number two, attempted CDS manufacturing distribution. They received a guilty. Unfortunately, manufacturing distribution is not an eligible conviction for expungement. There is no longer waiting period. It's just not eligible. So unfortunately, we don't even have to look any further. This case is not going to be expunged. It's not going to be eligible for expungement. Here we have case number three, the issuing of a false document. They received a stet in 2016. It looks like they were charged with it twice. Same stet, same 2016. This is not eligible today, but it will become eligible in 2019. So if I was this person, I would file for expungement of case number one. Fortunately, there's nothing you can do with case number two, and then I'd set a calendar reminder so that in 2019, I come back and expunge case number three. Okay, so that's expungement law in a nutshell. And I just want to say, there are some caveats there. There's always going to be a specific particular set of circumstances. So make sure you're comfortable, right? None of this is kind of legal advice. I'm not going to be the attorney for anybody here unless you contact MVLS. So make sure that when you file for expungement, you're comfortable that you understand the process. So let's talk about the forms here. So there's two forms to file for expungement depending on what type of case you had. There's one case if you did not receive any convictions on any charge in that case. You file one form per Technically, it's one form per incident, which is usually one form per case. Not one form per charge, one form per case. If you didn't receive any convictions, then you want to use this first form, which says acquittal, dismissal, probation before judgment, null pros, stead, or not criminally responsible. What you do is you fill out all the information. It's usually going to be your case information, so your case number, tracking number, defendant information, when you were arrested, whether you were arrested or received a summons, the police officer who arrested you, and the location, what you were charged with, the date that the case was disposed of, and then these check boxes represent the different potential avenues for expungement. And they also give a great overview of the law. If you get confused as to some of the timelines, you can use this to try and remind yourself as to, okay, it's a stet. How long is a stet? Do I have to wait? It'll say right here, a stet was entered, 3 years have passed, and I'm not now a defendant in a pending criminal action. And then you simply check the boxes that pertain to your particular case. So if you received a null pros and a stet, you would check those two boxes and then sign down here. It's a similar situation if you received a conviction that's eligible for expungement. You use this different but similar looking form, but it'll say guilty disposition on it. And all these forms are available at the court free of charge. And the same process. You simply check the box that applies to your particular case. Now, unfortunately, it's not great because the forms use these kind of long-winded statute numbers that don't accurately go over the actual charges that are involved. So that can be a little bit confusing. But if you ask the court clerk, potentially they can help you look it up. Some of them are a little bit more clear, like marijuana possession is right here. But this is a nuisance crime, and it's hard to tell unless you know what 10-105A9 looks like. So if you're filing for a case within 3 years, so it's one of those eligible cases, like a null pros, not guilty, that's eligible immediately, but you're filing within 3 years, this is the form you also have to file with it, saying you're not going to sue anybody. It's called the General Waiver and Release, and again, the courts will have copies of all of this. You basically write in your name, the person, the complainant's name, which is usually the police officer, and then the police officer's district. And then what you need, it looks like it has to be notarized. It does not have to be notarized. You sign over here on the bottom right, and you have to have somebody witness your signature and sign on the bottom left. This can be almost anybody. Try to make it somebody over the age of 18, and then have them sign. All they have to do, they don't have to know anything about your case. All they have to do is be able to know who you are, and sign as the fact that they saw you sign this piece of paper. That's it. You file this with the court with your petition form. Okay, so the easiest way to file is to actually go to the court and file in person. You get a stamped copy right then and there. You know it made it to the courthouse. So if you can do that, and the court clerks will catch anything like, oh, you forgot to sign here, you forgot to fill out this box. In theory, you can also mail it to the court. I'd only do this if you absolutely have to. But you can file 3 copies. You always first make a copy or a scan so you know what cases you filed for. So you have a record in case the paperwork never makes it to the courthouse. But what you do is you file the original and 3 copies with the court. And you can mail it to the court. But again, if you have the ability, take it to the court yourself and file it in person. So what is the time frame like? The state's attorney has 30 days to object from when they receive the petition. They usually receive it about 5 or 10 days after you file it. And so if you don't hear anything back in the first 45 days after you filed, it's usually a good sign. It means the state has not filed for an objection. They're going to let it go through. And in most cases, you're set and it'll be granted at some point. If there's no objection, then it usually takes between 4 and 6 months, if not a little bit longer, depending on the court and the court level, to get your file actually expunged. And they'll take it off of case search, and they'll send out orders to every agency that touched your case and tell them to also expunge their records. If there is an objection, so let's say you you messed up the timelines, you didn't realize it was 3 years, instead you tried to file a stet in 2 years, the state will object and a hearing will be set. They should send you notification of when the hearing is, and you can go and argue it. If there's some room to argue if the state made a mistake. If they didn't, you can also withdraw your petition and just refile later. What I do is basically wait 4 to 6 months. You should start receiving a whole bunch of paperwork from the court saying your expungement's been granted. Then go on Maryland Judiciary Case Search and make sure that the case has been removed. And you can do that, just search your name or search the case number, see if it still comes up. If you want to be certain, then you should go to the, you can get your full rap sheet by getting something called your CJIS report. And if you Google Maryland CJIS report, it's the first thing that comes up. They charge, it's state run, and they charge, I believe it's $36. And you go and you actually get fingerprinted, and that pulls up your full record. And if it doesn't show up on that either, then you're really good and everything's been expunged. So if you need some help with expungement, you can go to this website, mdexpungement.com. I'm going to demonstrate how it works here really quick. So this is Maryland Judiciary Case Search, right? If you just type in Maryland Judiciary Case Search, it's the very first thing that comes up. Read the terms if you want and click check the box to continue. And we're just going to look up a random person. And normally you want to leave the rest of it blank just to make sure you catch everything. But just for this purpose, I'm going to make sure we narrow it down here. Okay, so this person received a null pros. It is eligible for expungement. So let's say we wanted to get this case expunged. What we would do is we just copy this case number. We'd go over here and we could type it in. And this is mdexpungement.com. And it's free of charge, there's no fees or anything. You click expunge. It'll run it through a simple algorithm to determine if it's likely eligible for expungement. You should make sure that you've done your own analysis. This is just a tool to help you. It's not an attorney. There's no attorney on the other end reviewing everything. It's just a computer. So you can fix any of the information. Maybe your address has been updated, something like that. And what you can do is you can click expungement form. And the expungement form will populate with all the information that you need. Now, again, this is just a computer, right? It can always make a mistake. And so you should make sure that you're comfortable with filing it before signing your name and sending it to the court. But it is a good way to try to get the process started, especially if you get stuck somewhere where you need the form. And again, that's mdexpungement.com. And all you need for that is the case number. So using case search is a bit of an art form, right? I talked about it earlier. Some tips and tricks here are, if you see a case that doesn't have a disposition, like for instance right here, odds are it was forwarded to circuit court. It's either active or it was forwarded to circuit court. And on case search, district court and circuit court cases are separate. So if you start in district court and you want to have a jury trial, so you go up to circuit court, those are going to be two separate cases. And so if you can't find it, that's probably where it is. If you're searching case search, what you want to do is you want to do last name and first name. Do not include a middle initial or middle name. Many courts don't include it. And if you say, if you type in your middle name and a court didn't put in your middle name, you won't be able to see it. So leave your middle name blank. You want to select defendant as the party type, and you want to leave everything else alone. If you have a common name, it's going to be difficult. You can try to do it by date of birth, but if you're a John Smith, you're pretty much going to be out of luck. You can try narrowing it down by county and try to find those specific charges if you know you were only charged in particular counties. If you have a common name like that, or if you're a senior citizen and your cases potentially are older than 1990, you might need to go get your CJIS report, which will have your full criminal record. So case search does have its limits, but it's useful for most people. And try searching by other spellings if you have a commonly misspelled name. We've seen things like Sharon with 2 R's and 1 R, right? The court clerks typed in this information very fast, and so if people always misspell your name, try that name as well. When it comes to filing fees, it's unfortunately changes kind of frequently. If you were not convicted of that charge, then it should be, and you're filing in district court, there's no fee. So if you went to court, all your charges were null prost, you can file that petition and there's no filing fee. Now let's say it's one of the eligible convictions. Now that's only true in district court. Now let's say if it's one of the eligible convictions, marijuana possession, and it's been 4 years and now you're ready to file, then the filing fee is $30, and it's $30 per case. So if you have 5 cases where you were charged with, marijuana possession and a nuisance crime, and then maybe a theft misdemeanor conviction from 10 years ago, and you want to get them all expunged and they're all eligible, it would be $30 per case. So if it's a conviction, you have to pay $30. In most circuit courts, you have to pay $30 per case regardless. So even if you were found, everything was null prost, or you've got a conviction and it's eligible, you still have to pay the $30. The one exception is if you're actually found not guilty, then there's no filing fee attached with that. And you can call the courts ahead of time and make sure that you get all of the information and see what they charge with, and make sure to get the forms of payment too. So if you're interested in getting help, we do have income guidelines. You can find them on our website. We only help people that fall below a certain income guideline. But you can contact us at 1-800-510-0050, Monday through Thursday, 9 to 12. And if you qualify for our services, you can call and we'll tell you if you qualify. If you qualify for our services, we will place you with an attorney who will review your record on case search, create all the forms and the petitions that you need to sign. You'll either meet with this attorney at their office or at some kind of middle location, or you can do it all through the mail too. So the attorney might just mail you all the forms to sign, and you would just sign them and send it back. The attorney will file them. If there's anything wrong, they'll handle it. And the really great thing about going through us for help is that all the filing fees are waived. So if you have one of these convictions or 10 of these convictions that are eligible for expungement and you're looking at really steep filing fees, when we file them, they're automatically waived. Because we've already checked your income, and so we can tell the courts that they fall below a certain income level, and so they shouldn't have to pay the fees, and those are granted automatically. And so if filing fees become an issue, you might want to go through our service as well. So please feel free to give us a call, and we'd be happy to help you. Again, unfortunately, I can't comment on anybody's individual cases here today, but once you become a client of MBLS, either I'll become your attorney or another attorney will become your attorney, and then we can talk at length about your case and file your expungements. And I just want to remind everybody that this has been a brief overview of expungement law. There could still be caveats or unique circumstances with your case. So, if possible, see if you can have your forms and expungements reviewed by an attorney, or at certain courthouses, they have self-help centers with attorneys who manage it to give you quick advice. And there's always, things like lawyer in the library programs and different pro bono ventures. And so if you can, make sure you can have an attorney look through it. All right. Other than that, that is the end of the expungement training. I thank everybody for coming. I hope you learned a lot, and I hope you go and get your cases expunged. And if you run into issues, give this number a call, and we'll see if we can assign an attorney to either answer your cases or to actually represent you and file the petitions on your behalf. And if you're interested, our website, you can apply online as well. You don't have to call. Our website is mvlslaw.org. And I'll put that in the chat box here for everybody. And all you want to do is you want to do get legal help. And if you're just looking for legal advice, you're pretty sure you have the forms filled out. You can click get legal advice, and there's some information there. And then if you're looking at this, you have 100 cases, and it was all sounded very confusing, and you know you're going to need an attorney to help you out, you can do get a lawyer, and then either call in or you can do online intake down here. So thank you so much. That concludes the training. If you have any questions, feel free to write them into the question box or into the chat box, and I'll stick around for a little bit. And other than that, we're all good to go. Thank you so much. All right. I think that's it. All right. Thank you, everybody, and have a good day.